All rise. Veuillez vous lever. Please be seated.
Yes, Borovchan Defence Team. Mr. Gosnin, good morning, good afternoon to you.
Thank you very much, Mr. President. The prosecution told you three things in their final brief about the Popović footage of the Kravitsa warehouse on 13 July. The west entrance of the warehouse is open. 500 Muslim men are inside that west room, either dead or bleeding to death. And a massacre is underway in the east room of the warehouse at 5:15 to 5:20 p.m., which starts immediately after the massacre in the west room, where the 500 Muslim men are already dead or incapacitated. The prosecution, during its closing remarks last Friday, expressly or impliedly retracted each of these three claims. They now acknowledge that the first claim is just incorrect, that the second claim is therefore uncertain, and third, that there may have been a 30-minute interval between the end of the first shooting incident and the start of the massacre in the East Room. These are radical changes to the prosecution theory of the nature and sequence of events at the Kravitsa warehouse, as presented in their brief, which are, in turn, are fundamental to any determination as to what Borovchan may have seen. The mere fact of these changes reveals the speculative nature of their circumstantial case. But I would go further, Your Honors. I suggest to you that the prosecution's new position is actually incompatible with the inferences that they have asked you to draw. The bulk of my remarks today will be focused on proving that, and to situate these three propositions within the broader framework of the prosecution case. The prosecution alleges in its final brief that Mr. Borovchan, no later than the evening of 12 July, was fully aware of a plan to murder all Muslim prisoners who were being taken into custody by Serb forces following the fall of Srebrenica. The prosecution presents an alternative theory, however. They say that Borovchan, if he had no advanced knowledge of any killing plan, should still be found guilty on the narrower basis of what he saw and did late on the afternoon of 13 July. He is said to have witnessed an ongoing massacre at the Kravitsa warehouse late that afternoon and to have done nothing about it. The prosecution asserts that this makes him guilty of superior responsibility if the men doing the killing are his subordinates, or of some form of omission liability if the killers were not his subordinates. The prosecution has thus offered you, if you'll indulge what I believe is a useful simplification, a broad case theory and a narrow case theory. If your honors accept the broad case theory, then the precise sequence of events on 13 July, and in particular, what can be seen on the Popović video, will probably have little impact on your ultimate findings. If, on the other hand, you find that the broad case theory is unsustainable or even doubtful, then I suggest that the exact sequence of events on 13 July requires your anxious scrutiny. So let's start with the broad case theory. As expressed at paragraph 1878 of their brief, and I believe it should be coming up on the screens in front of you, the prosecution alleges that, and I quote at paragraph 1878, by the end of 12 July, Popović must have been fully aware of the VRS's intentions to separate and murder the Muslim men and boys of Popović. The OTP explicitly offers 3 arguments in support of this claim. The first argument, at paragraph 1914, is that, and I quote, any normal military order provides the subordinate command with the objective of the operation, and the VRS would have communicated as much to Popović. This is not a reasonable assumption, Your Honors. Is it really likely that someone at the most senior level of the VRS leadership who hatches a murder plot, a mass murder plot, would feel duty-bound to reveal such criminal intentions to any and all subordinates because of the niceties of military regulations? Momir Nikolic, the only witness who provided any direct insight on this issue, testified that the exact opposite was true. He did not mention the killing plan to anyone on 12 and 13 July, presumably on the understanding that he was supposed to keep the plan as quiet as possible. The prosecution's second argument, expressed at paragraphs 1858, 1908, 1914, and 1918 of their brief, is that A, the prisoners in Popović were abused, B, this abuse was witnessed by or known to Popović, and C, this abuse must have led Popović to infer that all prisoners were to be killed. Now, the OTP brief frequently associates the words separation and detention with abuse and execution, respectively, as if by frequent repetition, you, the chamber, should simply accept that natural inference. This claim is false on several levels. Detention of military-aged men is an accepted practice under international humanitarian law, and one that has been carried out by Western militaries in the past. It was perfectly justified in the particular of circumstances of Srebrenica, where all military-aged men were subject to conscription, where combatants frequently wore civilian clothing, and where there was a large armed column of Muslim combatants in the very near area. The practice of wholesale detention was common throughout the Balkan Wars, without mass executions ensuing. And even the internationals on the ground in Popović on 12 or 13 July did not believe that the detentions were improper, or, importantly, that the conditions of detention indicated that the prisoners were going to be executed. A valid question does remain, however, and that is whether Popović saw or would inevitably have learned of force that went beyond what was necessary to place the prisoners in detention, and on a scale sufficient for him to infer that there was a mass murder plot unfolding. So the issue, Your Honors, I submit to you is not whether he happened to be present in Popović for any part of the evacuation process. The issue, rather, is whether it can be safely inferred from the duration of his presence that he would have seen abuses that would have alerted him to a murder plan. The evidence, as we have extensively discussed in our brief, simply does not support that inference, both because of the surreptitious nature of the violence that did occur in Popović and the fact of Popović's only very brief presence there on the 13th of July. The prosecution argues, third, at paragraph 1916 of its brief, that Popović's failure to describe the purpose of detention in his post-operation reports implies that he was covering up a criminal intent. But first of all, Your Honors, Popović candidly says in both of his post-operation reports that MOOC forces did assist with the evacuation process. So there's no evasion there. Second, as Popović maintained throughout his interviews with the OTP back in 2002, and as the evidence shows, he did not have effective control over the deserters unit in Popović and its participation in the evacuation process. The passing discussion in his reports simply reflects his limited involvement. And third, Popović had absolutely no reason to engage in a lengthy justification of detentions in internal memos to his superiors. A detention process that, after all, had been ordered at the top levels of the VRS. So the failure to provide an extensive explanation or justification of these detentions is no evidence that he had a murderous intent on 12 or 13 July. The prosecution makes three other arguments that might be relevant to their broad theory. First, that the chamber can assume that the killings at the Kravitsa warehouse were a pre-planned execution from the start, because the killings there fit into the broader pattern of executions. That's wrong. The warehouse is 20 meters away from the main road. On the afternoon of 13 July, long convoys of buses filled with Muslim civilians were traveling along that road, potentially with UNPROFOR escorts. This was not a propitious place for a bloody massacre of 1,000 men. With the possible exception of Yadar River, which involved only a small number of victims, every one of the executions following Srebrenica took place far from the eyes of potential witnesses. Srpska, the only execution that arguably precedes the events at Kravica Warehouse, was carried out in secrecy, several kilometers off the main road. Nor were any ligatures found amongst the human remains alleged to have come exclusively from the Kravica warehouse. Nothing in the circumstances surrounding the detention of Muslim men in the warehouse on the afternoon of 13 July would have inherently suggested that they were about to be massacred, rather than being held there temporarily pending transfer to detention camps. As, by the way, was the case with all the other prisoners being detained along the road that day, who were being bused to Bratunac and then held temporarily in detention there. Second, the prosecution alleges that Borovchanin's order to stop traffic along the road was for the purpose of concealing the execution of prisoners at the warehouse. And this is at paragraphs 585 and 1988 of their brief. The most glaring fallacy in this reasoning is the assumption that there was only one reason to close the road, and that the road was closed only once. This is an unreliable assumption, as we discuss at paragraph 302 of our brief. Immediately after Borovchanin is heard saying that the road should be closed, the Petrović video shows two large caliber mobile guns on the road immediately in front of his vehicle, firing intensively into the countryside. The vehicles are in the right lane, but the guns are swung partly over the left lane. No buses are seen during this sequence of the video. So we submit that you cannot simply accept the proposition that the only possible reason for closing the road would have been to conceal these executions. Further, there are indications that the road was closed on multiple occasions and for different purposes. This flows from the audio of the trial video itself. This is P2985, page 10, in which Borovchanin's interlocutor says that someone else, a certain Kovac, has already taken care of closing the road. So I suggest that this provides at least a potential indication that the road was closed earlier for another reason. The broader context also belies the prosecution's allegations about the motivation behind this order. First, if Borovchanin had wanted to commit mass murder at Kravica warehouse and conceal it, why would he close the road immediately before the last convoy of buses is leaving Potocari and is soon to pass the Kravica warehouse? That last convoy is marshalling in Potocari at about this time, as can be seen on the Dutch Bat video footage, and I believe, as is a proper interpretation of the Petrović footage. And the prosecution asserted before you on Friday that the convoys continued until 8 p.m. But that's not what they say in their final brief at paragraph 379, where they assert, and I quote, by about 1800 hours on 13 July, the transportations were completed. If there was an intention to conceal the killings, wouldn't it have made more sense to let these buses through and then execute the prisoners without any chance of witnesses passing by? And if this was the purpose of the order, then why on earth would the checkpoint where these buses are being stopped be located only a few hundred meters down the road from the warehouse? Why would he have brought a journalist with a video camera along with him up the road? And then hand the video footage over to the OTP during his interview. Now, the prosecution tries to dismiss that. They say, well, he had to hand over the tape because he would have thought we already had it. But that's not true, Your Honors. Even in 2002, the OTP did not have that footage. They got it from Popović. And they've claimed that the reason why they didn't have that footage was because there was a concerted effort to conceal that footage. Now, if Popović is in all this, is it plausible to say that he doesn't know about this massive cover-up that the OTP is relying on to explain why they didn't get this footage until 2002? And wouldn't it have been smarter for Popović to claim, as he could quite easily have done, I just don't have this tape. No idea. He still could have massaged what he said during the interview. He still could have conformed what he had to say based upon what might later emerge. There would have been no comeuppance or embarrassment or implications of guilt if later that videotape had emerged from another source. In short, Your Honors, the allegation that Popović is closing the road to conceal a mass execution is sheer speculation, and implausible speculation at that. The prosecution relies on one last element for its broad theory of Popović's involvement in the killings. And that's the Krstić intercept from 8:40 p.m. on the evening of 13 July. The intercept can only bear the sinister interpretation advocated by the prosecution if the massacre at Kravica warehouse has already taken place. The best view of the evidence, however, taken in its totality, and I'll be going through it later, is that the full-blown massacre at the Kravitsa warehouse did not happen until nightfall. Borovchanen's answers during his OTP interview do not reflect any consciousness of guilt or an attempt to cover up. They are simply a legitimate rejection of unfounded allegations. For these reasons, Your Honors, and for all the other reasons that are expressed in our brief, we suggest to you that the prosecution has not established beyond a reasonable doubt that Borovchanin was driving up that road on 13 July with advanced knowledge of any impending mass execution. The evidence, in fact, suggests the contrary. In this context, Your Honors, we suggest that the details of the narrow case are important, and they merit your close analysis. The narrow case theory relies on two primary factual propositions. First, Borovchanin was at the Kravitsa warehouse during a mass execution that allegedly commenced at 5 p.m. And second, his men participated in these killings. No direct evidence supports these two allegations. The prosecution has relied instead on circumstantial evidence, and that requires them to exclude all other possible scenarios as unreasonable. A circumstantial case should possess, I submit, three characteristics to meet that standard. Coherence. Does the scenario pointing to the accused's guilt explain all of the available evidence without being internally contradictory? Consistency. Do the fundamental aspects of the scenario remain unchanged as new evidence is adduced? Trustworthiness. Is the evidence generated and disclosed in a manner that ensures that all possible alternative scenarios can be safely discarded as unreasonable? The defense bears a burden only to show that the prosecution has not done so, including by suggesting other reasonably possible scenarios, or more accurately, by suggesting other scenarios that cannot be excluded as unreasonable. Your Honors, you have our brief. We have presented you with a scenario that is not only eminently reasonable, but we say much closer to the truth of what happened than what has been put forward by the prosecution. The evidence strongly suggests that there were two distinct killing events. The first shooting event lasted between 10 and 30 minutes and was most likely a reaction to to a breakout attempt by Muslim prisoners. The bodies you see in front of the warehouse on the video appear to have been killed during this relatively short outbreak of shooting. An interval then ensues, during which time the prisoners are locked down in the warehouse. The exact duration of that interval is unclear, but probably, based on the best view of the evidence, lasts until nightfall. And only then did a deliberate massacre of the prisoners begin, continuing for a considerable period throughout that night. Now, Your Honors, again, we have no burden in presenting this theory. No evidential burden in any event. We admit that the theory is based on some speculation, which is merely a reflection of the fragmentary evidence that was brought before you. Nevertheless, we do assert that the sequence of events is not unreasonable. The prosecution has simply not been able to exclude the reasonable possibility that the first sequence of shooting was of short duration, that prisoners were shot in reaction to a breakout attempt, and that even this shooting event was over by the time Popović arrives or passes by the warehouse. The prosecution theory, as expressed in the closing brief, the scenario they've presented, is only credible based on ignoring a whole series of evidential issues that they don't address in their brief. There's no discussion at all of Mevlid and Orich's testimony. There's no meaningful discussion of Milos Djukanovic's testimony and his potential biases. There's no acknowledgement, much less discussion, of the divergent testimony of PW 111 and PW 156. There's no discussion of the evident problems with 156's testimony. And most importantly of all, and this is what it really comes down to, there's no analysis as to the relative weight of the conflicting testimony of 111 and 156. The prosecution tried to rectify some of those deficiencies on Friday, and I will be responding to that. Nonetheless, I suggest that the prosecution's analysis continues to be incomplete and superficial. Their brief does at least have the merit of offering a very clear hypothesis about the sequence of events at the warehouse. And here's the sequence that they gave to you. A pre-planned execution begins sometime between 4:55 and 5 p.m. By about 5:15 p.m., all of the prisoners in the West Room are dead or incapacitated. at approximately 5:15 or 5:20, so that's some 20 odd minutes into the killings, a Muslim prisoner manages to seize a rifle and kill 2 Serb soldiers. A third is injured grabbing the barrel, the overheated barrel of the gun. Borovchanin then receives a radio call concerning this incident and is told to come back down the road. Borovchanin does come back down the road, and according to the OTP, in their brief, arrives between 5:15 and 5:20 p.m. And then, as expressed in paragraphs 1992, 1989, and paragraph 611 of their brief, they say that when Borovchanin passes in front of the warehouse, killings are ongoing in its east room, which means necessarily that the killings in the east room are following immediately after the killings in the west room. Two important points of consensus on this scenario. First, the prosecution and defense agree that a Muslim prisoner did seize a rifle. Had that rifle long enough to kill one Serb and injure another. The only difference between the prosecution and defense on this point is timing. We say that this happened at the beginning of the shooting event. They say that this happened 20 minutes into the shooting. So that's the first point of consensus. Second, the prosecution's time frame as to the start of the first killing event, when it starts, and the timing of the likely timing of Borovchanin's arrival is roughly accurate. With one caveat. If the radio call was made to Borovchanin, as they've argued in their brief, between 5:15 and 5:20, and that's at 1990 of their brief, then we suggest that he could not have arrived at the warehouse instantaneously. We suggest that he would not have arrived for at least another 5 or 10 minutes, meaning that he likely arrived at the warehouse, and it certainly cannot be excluded as unreasonable that he arrived between 5:20 and 5:30 p.m. With the exception of that caveat, and even that caveat is not mutually exclusive with the prosecution position, we agree with that aspect of the scenario. Now, the essential question that leads you to is what's going on at the Kravitsa warehouse at that moment. The Petrovich footage is the central piece of evidence in this case, and here's what the prosecution says about it at paragraph 627. The Popović video shows two Serb soldiers standing in front of the two open doors of the west room of the warehouse with their backs to the warehouse. This provides a clear indication that there was no reason to guard or be threatened by any of the 500 Muslims in that room. Meaning, all the Muslims in the west room of the warehouse were dead or incapacitated at the time Borovchanin and Popović drove by the warehouse. This is at the core of their case for four reasons. If true, firstly, it would show that a mass execution, rather than the suppression of a breakout attempt, had already occurred at the warehouse. Second, if true, it would imply or could imply that Borovchanin might have seen at least some of the bloody aftermath of that massacre. And certainly, or presumably, would have had to infer that something more, that a breakout attempt had occurred. Third, if true, the casual demeanor of the soldiers, which is recognized by the prosecution on the Popović video, which might otherwise suggest that in fact there's no shooting going on at the warehouse at that moment, that's attributable instead to the fact that everyone in the West Room is dead or incapacitated. And finally, if the doors are open and everyone is dead, this corroborates 156's testimony that the initial killing event was a massacre and was more or less continuous starting at 5 p.m. And again, the relative stories of 156 and 111 are crucial to this case. So there you have, Your Honors, 4 critical inferences arising from this assertion that the west entrance of the warehouse is open. On Friday, the prosecution came to you and told you something very different about the Popović footage. And I quote, "I've offered to enter an agreement of facts for the record for you that these doors are closed. So we cannot now conclude, as easily as we could before, how many people are dead, except that group of 15, 20, 30 that we see scattered all the way from one side of this photo to the next. That's a lot." End of quotation. Mistakes can happen in any large case, Your Honors. There's no doubt about that. But let's put this in context. This is the third trial at this tribunal involving the Kravitsa warehouse. The prosecution has been investigating this for more than a decade. This trial has been going on for 3 years. The prosecutor recognizes that these events are a trial within a trial and require that level of evidential proof. And here we have a claim, a factual claim, that is inextricably bound up with the assertion that 500 people are dead or bleeding to death. Thus casting into doubt that assertion on the eve of closing arguments. Four weeks ago, they filed their brief. They said to Your Honors, trust us. You can safely convict Popović and send him away for the rest of his life. Because we know what happened there. Here's the scenario. And here's a piece of the puzzle that supports that scenario. You can safely infer that 500 people are dead. There's a massacre taking place at this very moment on the video. And there's Popović right in the middle of this bloodbath. Well, as it turns out, Your Honors, they're wrong. And now they've admitted they were wrong on that point. The gravity of this error is compounded by something the prosecution did not see fit to mention to you last Friday. In the last few days, the prosecution has given us approximately 230 photographs, previously undisclosed, of the Kravitsa warehouse. Including photos that show fragments of metal doors at Glogova. And photos of doors from the warehouse complex with door handles corresponding precisely to the position and shape of the white marks on the Popović video at the center of the supposedly open entrance that the prosecution said in its brief was a window. Some of these photos date back to 1999. These are crime scene photos. Some of them are, as we now know, highly exculpatory. And for years, they've gone undisclosed. Your Honors, you will never know just how close you came to never hearing about the prosecution's mistake. I can't tell you how much we hesitated to make the argument that we did in our brief, because we could not determine with certainty what we were looking at in the center of that west entrance. You can see the hesitation, though, in paragraph 150 of our brief. What I can tell you is this: the non-disclosure of those photos could easily, very easily, have been the difference between this coming to light and this not coming to light. You quite easily might never have heard the true story about the west entrance of the warehouse. And that, in turn, might have induced you to draw a dramatically wrong inference that a full-blown, bloody massacre must have been underway. Rather than that this might have been the suppression of a breakout attempt. I suggest that this ought to give you a very serious pause and concern about the overall reliability and trustworthiness of the prosecution case. It's not just the visible errors now that you have to worry about. The prosecution said nothing more about this error during their closing remarks, other than the passage that I have just quoted, implying that it was no big deal. It is a big deal, Your Honors. It's a big deal because of the non-disclosure. It's a big deal because it's the basis for claiming that 500 people are dead. It's a big deal because it's being used to prove that this was a premeditated massacre from the beginning. It's a big deal because this, in turn, was suggested to you as the basis for you to draw the inferences about Popovic's state of mind and knowledge. But let's recap the argument again that was presented by the prosecution. Because A, the doors are open, combined with B, these soldiers walking casually in front of the warehouse. Therefore, C, 500 people are dead inside or bleeding to death. D, Popović is driving by at that very moment. E, this indicates that Popović is there in the middle of a pre-planned mass murder. And F, the chamber should infer, therefore, that either he intended this mass murder or is guilty of mass murder for not intervening. That's their case. Or at least that was their case a month ago. and the prosecution recognized that the inference that they had suggested was wrong in their remarks on Friday. Let me repeat again what the prosecution said in this regard on Friday. We cannot now conclude, as easily as we could before, how many people are dead, except that group of 15, 20, 30 that we see scattered all the way from one side of this photo to the next. That's an astonishing retreat at this stage of the proceedings. Here is the prosecution admitting, acknowledging, in closing arguments, that as few as 15 prisoners may have been dead at the warehouse at this point, abandoning the claim in their brief that at least 500 are dead or bleeding to death. The prosecution change of position raises a number of other, more general questions that may be just as important as the issue of this specific inference. Do you know, Your Honors, with any precision, having heard the prosecutor on Friday, having said no more than just this quotation, what other parts of the circumstantial case have now been affected? What parts have been abandoned? What parts are now less probable? What parts are intact? More broadly, can a circumstantial case like this, with a serious factual error at its core, be trusted? Can Your Honors have confidence in a case that changed in such a fundamental way? What is left of this case, whose central claim is that there's a massacre ongoing while Popović is there? Now, Your Honors, the closed doors issue does not prove, of course, that there were no killings going on elsewhere in the compound at that moment. But here's what does prove that. 111 is in the east room of the warehouse. No one disputes that. At paragraph 611 and 1989, the prosecution asserts that the executions are going on in the east room when Popović passes by, which they say is at 5:15 to 5:20 p.m. Much to my surprise, on Friday, the prosecution accepted 111's testimony that there had been, at a minimum, an interval of 30 minutes between the end of the shooting incident on the west side of the warehouse and the start of the massacre on the east side of the warehouse. a 30-minute interval. And let's see exactly what the prosecutor said on this point. And I quote, "Witness 111 clearly says that a half hour passed between the shooting that he heard on the other side of the warehouse and the time the shooting happened on his side." And then a little further on, prosecutor says, "What he's absolutely clear on is that his executions happened half an hour after the ones that happened next to him." And we know that this happened about 5 to 5:30 when the lull occurred. I suggest to you, Your Honors, that the prosecution is caught in a fundamental contradiction here. I'm told there's no BCS translation.
Yeah, we have to check that, obviously. I mean, I'm not in a position to know. Do you have a translation? Yeah. All right, so Mr. Gosner, can we proceed? The problem seems to have been solved anyway, if it ever existed.
I apologize.
It's okay, go ahead.
I'm informed that when I started reading the quotation, that was when the BCS translation was lost. So with your permission, I would simply like to repeat that.
Repeat it, yeah.
Thank you. So here's what the prosecutor said. And I'm starting at line 18 from page 3425 of the transcript. Witness 111 clearly says that a half hour passed between the shooting that he heard on the other side of the warehouse and the time the shooting happened on his side. And further, at 34236, what he's absolutely clear on is that his executions happened half an hour after the ones that happened next to him. And we know that this happened about 5 to 5:30 when the lull occurred. The prosecution is caught in a fundamental contradiction here. In their brief, the prosecution said that the killings are ongoing in the East Room when Popović passes by at between 5:15 and 5:20 p.m. But now we hear the prosecution accepting the testimony of 111, who was in the East Room at the time, that he heard an initial outbreak of shooting on the other side of the warehouse. That lasted half an hour. So this is the time frame between 5 and 5:30 cited by the prosecutor. And that then there was a half-hour pause before the shooting commenced on his side of the warehouse. But taking the prosecution's current timeline, accepting 111's testimony, that means that the killings in the East Room did not start until about 6 p.m. And then if you go back to the timeline in their brief, that's 40 minutes after Popović is supposed to have been there. And what's more important than exact times, because everybody recognizes, as they should, that 111 might not be absolutely precise about times. But bear in mind two things. One, what's essential here and what can't be disputed is the sequence of events as they follow one another. And two, in assessing that sequence, what you're asking yourselves is, can I exclude the possibility that Popović was not there during that interval? Can I exclude that based on the evidence? More generally, I have to say I don't know now what the prosecution position is. Were the killings ongoing in the East Room at 5:15 to 5:20? Or weren't they? And the prosecution is confronted with another, even more serious problem by accepting 111's testimony about this half-hour interval, about the fact that there was this interval, whether it was 20 minutes, 40 minutes. They simply cannot now credibly exclude the possibility that Popović was there during that interval, that that's when he passed by the warehouse. They can't tell you with a straight face that they know with any degree of certainty the duration of that first outbreak of shooting that the prosecution says was on the west side of the warehouse. PW 111 says it was 30 minutes. He might have slightly overestimated. Đukanović says it was 10 to 15 minutes. Now, Đukanović, of course, is a Serb. But take a look at his evidence. Take a look at his biases. Take a look at the way that he answered questions. And ask yourselves whether on that issue, Đukanović would have been biased, first of all, in favor of Popović, or secondly, whether he would have had any idea whatsoever of the implication of his testimony at the time. And I think when you look at that, Your Honors, even applying the most negative suspicions about the reliability of Serb testimony, you'd have to say that on that point, he had no particular reason to lie. And by the way, on this issue of the duration of that first killing event, the prosecution strains very hard to explain how at least one of the Serb injuries, one of the injured Serb soldiers, managed to get down to Bratunac by 5:30. That's an added piece of the puzzle that I suggest ought to suggest to you that that first killing event is rather short. And once there's doubt about the duration of that first killing event, Your Honors, I suggest you can't draw the inference that he was there during that first outbreak of shooting. Now, PW 111 does give two different estimates concerning the duration of this interval between the two shooting events. And the reasons are clear. His testimony has to be read according to the trauma that he obviously survived during this time period. But the length of the interval is reliably indicated by Mevlut and Orich. Orich stops in front of the warehouse at dusk on a bus from Konjevich-Polje to Bratunec, full of Muslim prisoners. The key aspect of Orich's testimony is not what he can directly see is going on in the warehouse at that moment. The key aspect of Orich's testimony is that he sees 400 to 500 Muslim prisoners gathered in front of the warehouse, waiting to be loaded onto buses. The buses and the bus that he was on stops, and some or all of those 400 to 500 Muslim prisoners who are sitting there waiting are loaded onto that convoy of buses. I suggest to you, Your Honors, that the presence of 400 to 500 Muslim prisoners at that place, at that time, in that way, is not consistent with an ongoing massacre of 1,000 people, which the prosecution situated in its brief, clearly situated as having occurred between 5 p.m. and nightfall, following adopting 156's testimony as the correct version of events. And I make that submission whether the killings were sporadic or ongoing. Even if they were sporadic, the presence of those individuals must raise a reasonable doubt as to whether or not that's what was going on at that time. And if we follow Orich's testimony, then what does that interval tell you? For that matter, what does the existence of any interval, of any duration, tell you? Well, I suggest that it shows you several things about what did happen or what may have happened, because that's the standard that we on the defense side are required to discharge. What may have happened, what reasonably may have happened. One, that the first killing incident may have stopped following Djukanović's testimony after a relatively short period. That would suggest that those killings were not pre-planned, that it was not a massacre, that in essence, it was the suppression of a breakout attempt. And in our brief, as you know, we discussed the contours of exactly where the line might be between the suppression of a breakout attempt and something more. But we suggest to you that the genesis of this shooting event was a breakout attempt, and it can't be said with any reasonable degree of certainty that that devolved into a massacre. Second, you cannot reasonably exclude the possibility that Borovchanin arrived during that interval, and that when he stopped, he was told that there had been a breakout attempt. And third, if you do accept that there was an interval of some significant duration, you can't exclude the possibility that what happened at the warehouse, the mass execution that did occur there, was on the basis of subsequent orders, subsequent coordination, subsequent decision. And we say that the best view of the evidence is that that occurred at nightfall. Now, the prosecution referred on Friday in order to rehabilitate the claim that a large number of people had been killed during the first shooting event, or to cast light on the nature of the first killing event, asserted that there was evidence in this case that grenades were used during that first event. Well, Your Honors, this argument didn't make it into their brief. And that's not surprising because the evidence supports no such thing. They cited 3 sources. You now have the relevant passage from PW 111 on the screen in front of you. I won't read it. I suggest to you that it's obvious from the content of his answer that he's not talking in that response about what he heard specifically at the warehouse. And I suggest that to you because there's never been any evidence, and there is no evidence in this case, suggesting that there was an anti-aircraft gun there shooting in any direction, much less a tank shooting artillery. So I suggest he's clearly not referring there to what's going on in the compound. Second, Borovchanin does not say, contrary to what the prosecution asserted on Friday, that he heard detonations at the Kravitsa warehouse at that moment. He does hear detonations at around this time, but it is simply not clear from the interview transcript where he believes these detonations are coming from. Finally, it's just not true that if you listen to the trial video, you can hear detonations from the Kravitsa warehouse at around this time. Your Honors, 3 years ago, you heard the prosecution say in their opening statement, at 493, quote, "So this incident with that the burned hands took place. We're confident that it did. But not the way the Serbs say it did. That, the Serb version, is not reasonable. 3 years later, here we are. I would suggest to you that the prosecution claim in its opening statement has not been substantiated. In fact, this so-called Serb version is not the Serb version. It can be drawn most fundamentally from two Muslim survivors who have absolutely no motivation to lie. Now, Your Honors, I am about to proceed to a new topic, and so I would ask
Yes.
that we adjourn.
Fine with us.